Hi guys, welcome to the previous year questions discussion by from INSPIRO KAS. Today we will be discussing a question from 2021 KS examination. So basically this is question number 8 in your paper, and this question is basically taken from your Polity and PubAd together. Like you can look at it from different perspective. So one is like say for example from the perspective of judicial activism or judiciary per se, or other one from the angle of rule of law. So how exactly as to public interest litigation has helped in India achieving what is called as rule of law or access to justice, etc., etc. So from multiple perspective, we can look at this question. So if you actually look into the question simply says explain the concept of public interest litigation. So the first part is asking us to explain as to what exactly is public interest litigation, or what do you know or what do you understand by this term public interest litigation. ಅದು ಏನು ಏನಂತ ವಿವರಿಸಬೇಕು ನಾವು ಅದರಲ್ಲಿ. Next is go on to ask us like how exactly this public interest litigation, whatever we have understood in the first part of the question, is helping us achieve what is called as social justice, and don't simply say that this will lead to this, etc., etc. You justify your answer with some examples. So don't give me a superficial answer or a vague answer saying that PIL will lead to A, B, C, D, E, F, G. You tell me exactly as to which case or any example as to what was the case which was decided by Supreme Court coming at conclusion of social justice. So this is what the question is asking. So to summarize ಅಂತ ಅಂದ್ರೆ PIL ಅಂದ್ರೆ ಏನು, ಅದರ ಫ್ಯೂಚರ್ಸ್ ಏನು, ಪ್ಲಸ್ ಅದು ಹೆಂಗೆ ಇಂಡಿಯಾದಲ್ಲಿ ಹೆಲ್ಪ್ ಮಾಡಿದೆ ಟು ಅಚೀವ್ ವಾಟ್ ಈಸ್ ಕಾಲ್ಡ್ ಅಸ್ ಸೋಷಿಯಲ್ ಜಸ್ಟಿಸ್. ಸೊ ದಿಸ್ ಈಸ್ ದ ಬೇಸಿಕ್ ಡಿಮ್ಯಾಂಡ್ ಆಫ್ ದಿ ಕ್ವಶನ್. ಸೊ ಐ ವುಡ್ ಸೇ ಮೇ ಬಿ ಇಲ್ಲಿಗೆ ಒಂದು 5 ಮಾರ್ಕ್ಸ್, ಮೇ ಬಿ ಇಲ್ಲಿಗೆ ಒಂದು 7.5 ಮಾರ್ಕ್ಸ್. ಸೊ ದಿಸ್ ವುಡ್ ಬಿ ಮೈ distribution, or you can go for 6 also. So 6 marks as to what is public interest litigation, and the remaining 6 marks as to justifying how my public interest litigation has helped address the social justice in India. So now going to that answer ಅಂತ ಬಂದ್ರೆ maybe I would expect what is called as public interest litigation ಅಂತ ಒಂದು ಡೆಫಿನಿಷನ್ ಕೊಡಬಹುದು, or you can simply say that opening statement like the concept of public interest litigation ಏನಿದೆ ಅದು ಎಲ್ಲಿಂದ ಬಂತು, ಇಂಡಿಯಾದಲ್ಲಿ ಯಾರು ಅದನ್ನ ಪಾಪ್ಯುಲರ್ ಮಾಡಿದ್ರು. ಸೊ ಮೈ ಓಪನಿಂಗ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ವುಡ್ ಬಿ public interest litigation is an idea or is a product of judicial activism which originated in United States of America, and it was made popular in India by the Supreme Court judges ಯಾರು ನಮ್ಮ ಕೃಷ್ಣ ಅಯ್ಯರ್ ಯಾರಿದ್ದಾರೆ ಆರ್ ಪಿ ಎನ್ ಭಗವತಿ. ಬೇಸಿಕಲಿ ಇವರಿಬ್ರು ದೇ ಪಾಪ್ಯುಲರೈಸ್ ದಿ ಕಾನ್ಸೆಪ್ಟ್ ಆಫ್ ಪಬ್ಲಿಕ್ ಇಂಟ್ರೆಸ್ಟ್ litigation. So this would be my opening paragraph where I would simply say the concept of judicial activism originated, I mean the concept of public interest litigation is a product of judicial activism which was basically originated in United States of America and made popular in the 1980s or 1990s, whatever you want to quote, by Justice P. N. Bhagavati and Justice Krishna Iyer of the Supreme Court of India. You start ಮಾಡ್ತಾರೆ. So why this is important? So now my next paragraph is going to address that question as to see basically I would say like in any judicial case or anything that you want to file in the case ಅಂತ ಬಂದಾಗ we have something called as locus standi, meaning to say what is your standing in this one, like are you a person who are losing from it ಅಂತ ಹೇಳಿ. So here my second paragraph would address this issue that so this public interest litigation ಏನಿದೆ, this is taking away the traditional locus standi which says that any person whoever rights are infringed that person only can go ಅಂತ ಏನಿದೆ, that is being relaxed in this one, meaning to say in the second paragraph I will justify as to what is PIL. Here I am going to elaborate. My elaboration would say that in this the public interest litigation relaxes the locus standi and allows any public minded citizenry or publicly active citizenry to file a case for the downtrodden or the marginalized sections of people and in standing. Second one I would say is procedural flexibility. So basically what was the procedures that we have to follow in there, that has been relaxed to some extent so that the court can address the issues at a faster rate for a faster pace, and this gives life to what is called as judicial activism, rule of law. So ಈ ಮೂರು ಪಾಯಿಂಟ್ ಐ ಆಮ್ ಗೋಯಿಂಗ್ ಟು ಸೇ ಇನ್ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್. ಸೊ ಪಬ್ಲಿಕ್ ಇಂಟ್ರೆಸ್ಟ್ ಲಿಟಿಗೇಷನ್ ಅಂದ್ರೆ ಏನು, ಅದು ಇಂಡಿಯಾ ಯಾರು ತಗೊಂಬಂದ್ರು ವುಡ್ ಬಿ ಮೈ ಓಪನಿಂಗ್ ಪ್ಯಾರಾಗ್ರಾಫ್, ಅಂಡ್ ದೆನ್ ದ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ವುಡ್ ಜಸ್ಟಿಫೈ ಆಸ್ ಟು ವಾಟ್ ಎಕ್ಸಾಕ್ಟ್ಲಿ ಇಸ್ ಪಬ್ಲಿಕ್ ಇಂಟ್ರೆಸ್ಟ್ litigation. So explain the concept of public interest litigation. So what it is and what are the features of that one. So this I am going to justify in the first two paragraphs. So once my this thing is done, Now that I have created what is called as a curiosity creator, now my answer would be what is the next part which says discuss how it has helped in social justice. So basically ಇವಾಗ ನಮಗೆ ಫಸ್ಟ್ ಅಲ್ಲಿ ಗೊತ್ತಾಯ್ತು ದಟ್ ಇದು ಪಬ್ಲಿಕ್ ಇಂಟ್ರೆಸ್ಟ್ ಲಿಟಿಗೇಷನ್ ಅಂದ್ರೆ ಲೋಕಲ್ ಸ್ಟ್ಯಾಂಡರ್ಡ್ ತೆಗೆದಾಕಿದೀವಿ ಅಂತ. ನೌ ಐ ಹ್ಯಾವ್ ಟು ಜಸ್ಟಿಫೈ ಮೈ ಆನ್ಸರ್. ಸೊ ಹೌ ಡು ಐ ಜಸ್ಟಿಫೈ ಮೈ ಆನ್ಸರ್? ಆಸ್ ಐ ಸೆಡ್ ಆಲ್ರೆಡಿ, ವಿ ಶುಡ್ ನಾಟ್ ಸಿಂಪ್ಲಿ ಸೇ ವೇಗ್ಲಿ ಅದಾಗಿದೆ ಇದಾಗಿದೆ ಇಲ್ಲ. ಸೊ ವಿ ವಾಂಟ್ ಕಾನ್ಸೆಪ್ಚುಯಲ್ ಕ್ಲಾರಿಟಿ with some proper examples. So what is the proper examples? You would have to go back to so many of the things which you already have studied this one. So ನಿಮಗೆಲ್ಲ ಗೊತ್ತಿರೋ the example. So my first opening would be the first one, which is basically the Vishaka rights. Women rights issue ಏನಿದೆ, Vishaka versus state of Rajasthan. So we all have studied in our Polity and PubAt class. Basically Vishaka guidelines ಅಂತ ನಾವೆಲ್ಲ ಓದಿರ್ತೀವಿ. Vishaka guidelines regarding to like violence at workplace ಏನಿದೆ, prevention of sexual harassment at workplace. So first one I would say Vishaka versus the state of Rajasthan led to the enactment of what is called as Vishaka guidelines. Or second one I would say MC Mehta versus Union of India case. So basically this was a case where this industrial effluents were left to Ganga. So Ganga, the Ganges was being polluted. So here the court said that so basically the absolute responsibility ಅಂತ ಏನಿದೆ ಅದನ್ನ liability for the industry whoever is polluting ಅಂತ ಹೇಳಿ they got what is called as pollution industries, they were made accountable for the pollution that they are going to cause. Or the recent examples which we all know. So basically this one ಏನು ನಮ್ಮ ಪ್ರೇಮಾನಂದ್ ವರ್ಸಸ್ ಯೂನಿಯನ್ ಆಫ್ ಇಂಡಿಯಾ, ಪ್ರೇಮಾನಂದ್ ಕತ್ರಾ ಅಂತ ಹೇಳಿ ಪರಮಾನಂದ್ ಕತ್ರಾ versus Union of India case. So basically we all know that whenever an accident is going to happen, hospital ge karಕೊಂಡು ಹೋಗ್ತಾರೆ. So the procedural issues were being followed earlier, so which led to delay in medicine or the treatment, and the patient would die eventually, or like because of the not availability of the treatment. So here in this Premanand Kata versus Union of India, Supreme Court said that so basically that hospitals are there to save the life and not the legal troubles. So basically it said in case of emergency, the first thing was to give treatment. So the complete freedom was given to hospitals to attend what is called as emergency without going through this legal procedures. So this one was provided via this case by the Supreme Court of India in the Premanand Katra versus Union of India case. So these kind of things you need to quote exactly as to what is happening in which case, in which thing was provided. So ಈ ತರ ನಾವು ಕರೆಕ್ಟ್ ಆಗಿ ಬರ್ಕೊಂತ ಹೋದ್ರೆ that is when you get the proper answer ಆಗುತ್ತೆ and you will get the proper marks also. Maybe you have many other cases like Vinit Narayan versus Union of India, which you all have studied with respect to like ನಮ್ಮ enforcement authorities ಏನಿದೆ to go into the corruption allegations cases ಇರಬಹುದು. Or we have right to education, Unni Krishnan versus state of Andhra Pradesh ಅಂತ which you all studied when you were studying article 21A ಏನು ನಮ್ಮ right to education case ಏನಿದೆ, that right to education ಅಲ್ಲಿ we all have studied compulsory education ಏನ್ ಕೊಟ್ರು, Unni Krishnan versus state of Andhra Pradesh, basically 2000 case. Like either cases and all you can go into court. If you write the year, happy. If you are not able to remember the year properly, it's okay, but I would expect at least a case, Vishaka case antlo illa MC Mehta case antlo illa Premanand Katra case antlo, at least names barbeko, because the question is clearly asking us as to explain with the help of decided cases anta heli. So maybe on 2-3 cases, at least 3-4 cases if you can write, that should be more than sufficient. So maybe in the conclusion you can say that by the above cases the Supreme Court has widened the scope of judicial activism, or as widened the scope of public access to judiciary or that judgments, etc., etc., so that the whenever the issues are being faced by the people, they are addressed in a faster manner or in a better manner, so that justice can be delivered. So what was under Article 32 matra ಏನಿತ್ತು, now it has been widened. So no need to write this Article 32 on, but I would simply end my answer by saying that thus the public interest litigation has widened the scope of judicial activism, thereby making the justice access to everyone. So that would be my answer. So first paragraph would be what is PIL, where is it originated, and who are the pioneers of that one in India, Bhagavati and Krishna here. Then my second paragraph or the second point would be like the PIL, what is it basically ಅಂತಂದ್ರೆ ಲೋಕ ಸ್ಟ್ಯಾಂಡರ್ಡ್ ತೆಗೆದಾಕುತ್ತೆ, and then This will give to what is called as one public minded things can, I mean, the public minded individual can go and apply cases ಅಂತ ಕೊಡ್ತೀವಿ, and then ಒಂದು faster access to justice, and then judicial activism ಗೆ ಇದು help ಮಾಡುತ್ತೆ ಅಂತ ಹೇಳ್ತೀವಿ second paragraph ಅಲ್ಲಿ. And then in the third paragraph where we address the second part of the question, there I am going to answer this with the help of Vishaka guidelines, Mehta, Parmanand Saha, and then Vineet Narayan, etc. etc. 4-5 cases I am going to write and conclude my answer. So this is what is expected in an answer. If you simply say like the general agi, it gave to women rights, it gave to that one, it gave to this one, it protected tribal rights. Yes, tribal rights are protected. Which case? That's what I'm looking at. Yes, is provided to so and so. It widened the Article 21A, I mean 21 right to life ಏನಿದೆ, the entire expansion of Article 21A, many cases were, I mean 21 right to life, many cases were from public interest litigation only. But if you don't tell me the case, there is no point in the answer, because the question is very clear in asking as to explain with the help of decided cases only. They are not simply asking how it has helped in achieving social justice. Ishte agogiddre whatever you want you could have written here without the case mentioning any case name. But here specifically they are asking ಆಗಿರೋದ್ರಿಂದ I would want you to write the case names only. Okay, thank you guys.
Sir. Can they write like this, sir? Social justice, each factor on like social justice, like about equity, access to resource related any case ಬಂದಿದೆ, equity related one case ಬಂದಿದೆ.
But we won't study in like that, na sir, because from the exam point of view, whatever we know, that one only we have to write now. Like in the before only we don't study and go na this one.
Correct only, sir. So it's better is like a cases in some few cases we take in that what justice, social justice.
Exactly. Exactly. And these are all we study. ಇವಾಗ when we are studying women rights ಅಂದ್ರೆ we write in the answer only na, Vishaka guidelines Supreme Court gave ಅಂತ we write.
Okay.
So Vishaka guidelines was PIL only. ಇದು ಅಷ್ಟೇ. ಯಾವುದು Parmanand Katra, same thing only. Like when we are studying about this current affairs and all, we would have heard this case in Parmanand Katra anta or MC Mehta. When we are reading this Ganga action plan, etc., we say in first Ganga action plan started by Supreme Court only, absolute responsibility, liability anta. We say MC Mehta versus, so whichever cases we know, that we have to convert that to this one. Instead of that social justice, we can go like what you said, environmental, state rights, children rights, we can go. But in the exam hall, we don't know that cases, na.
Correct, sir. Okay, sir. Fine, sir.
And then even if I say the cases also antandre, student will feel like, okay, this was prepared the answer and telling, okay, everybody can prepare and tell. I don't know, I have never heard these cases anta they will think na.
Okay, sir.
Like there are some cases like Vishaljeet versus Union of India anta varutte, child rights. But basically, I only never heard that case. Just good if you can remember in that way. But since most of the times case studies or the Supreme Court cases, whatever we study, we are not categorized them into PIL cases, like social justice cases or women guidelines cases, etc. Because PIL per se is a small topic where we will be learning 4-5 cases only. So if you go by that categorization of women rights cases, social justice cases, education cases, environmental cases, health issue cases, good if you can do that way in such a way. But I would say that is not needed, and that will not get you so much of content or data as we are not prepared in that manner. So if you're prepared, good. But I would say many of the students, like 95% to 99% of the students, simply know these cases because they have heard at one place or the other. See, without knowing about Vishaka guidelines, we cannot proceed about women rights. Without knowing about this one, like that golden hour anta naven heltivi, that we cannot proceed. So these kind of cases students would have heard somewhere or the other. So using that idea or that concept, convert that into answer and present it in a decent manner. So I would say doing that is better, because identifying cases in this manner, women rights cases, environmental cases, etc., etc., is good provided you have prepared PIL as a separate topic. But since the syllabus alli PIL anta it is not as to like explicitly illa. So we have to bring PIL from the judicial activism or etc., etc. So I would say just going with this rights cases would be more than sufficient.
Okay.